At this time, we'd like to welcome you to the 2013 Year-End Review and Compliance Forecast for 2014. We'll now turn the call over to Ms. Steve Knutson. So may begin.
Thank you, operator, and thank you everyone else for joining us for our 2013 Compliance Review and 2014 Forecast. Compliance has been hosting this webinar for several years now, and we're glad to have you joining us today. My name is Steve Knutson, and I'm the Senior Director of Business Development at Compliance Point. For those not familiar with Compliance Point, we provide consulting services to hundreds of companies, including several Fortune 500 companies, marketers, private sector schools, and debt collection companies. Our services include compliance audits, call center monitoring and enforcement, compliance training, and expert witness services. Our services are designed to ensure our clients comply with state, national, and international consumer protection regulations. From Compliance Point, we have Ken Sponsler, the President and General Manager, Matt Nagel, Senior Director, and Steve Nidek, Director. Also joining us today is Bill Rainey, a partner at the law firm of Koplovitz and Cantor. Bill's practice focuses on First Amendment issues and compliance with state and federal telemarketing laws. Clients include publicly traded companies, trade groups, companies that outsource consumer telephone contact, and telemarketing service bureaus, both in the United States and overseas. Today, begin by reviewing the regulations that went into effect in 2013. We'll review a few enforcements from the 2013 year, along with lessons learned from those enforcements. Next, we'll discuss a few bills that could go into effect in 2014, and then Ken will discuss some of what he's learned from his expert witness work in TCPA-related class action. Conclude by quickly discussing a few items from Canada. Now I'll turn it over to Steve Nidek to give us the regulatory review.
Steve, and welcome everybody. 2013 brought some very significant changes to the telemarketing laws at the federal and state levels. It is critical that you're aware of these requirements as they change and ensure your organization is adjusting processes and procedures as new regulations emerge or existing regulations evolve. So during the next few minutes, I'm going to review a few of the more significant changes that could have the greatest impact on your company's ability to contact consumers. I just want to make a note that this overview will not cover all of the changes that occurred in 2013. So if you'd like more information or have specific questions, please just contact us after the presentation, or you can even use the chat tool if you have a question in this platform. Obviously, the biggest change in 2013, and probably the biggest change in the law since 2009, has been the TCPA amendments that took effect in October. I'm not going to go into any great details on this because we think you've probably all sat in on at least a couple webinars specifically covering this topic. These amendments have certainly had an impact on telemarketing, applicable to auto-dialed calls, to cell phones, as well as the FCC's rules surrounding the delivery of pre-recorded messages to both cell phone and landlines. This has been and continues to be a main focus and priority that our clients have been dealing with. Since onus is on the marketer, real or defendable position against complaints and investigations, we've been busy helping companies with some of the challenges of these new laws. So this includes ensuring methods are in place to collect consent over every customer touch point, so websites, inbound calls, outbound calls, and email campaigns, just to name a few. You must confirm that your language and the method of consent is clear and conspicuous and includes all the necessary disclosures. You must also ensure that you're maintaining records of consent for as long as you plan to dial these consumers, and also make sure that you can prove the dial methods with these calls. So if you're dialing it via a non-ATDS system, you make sure that you're able to prove that. Important things to note and consider: these rules apply to your existing customers as well. So if you have a database of current customers, including their cell phones, calls may really only be placed legally to them via an ATDS if they provided consent under this new standard. So I'll keep in mind that if you're purchasing leads from lead aggregator sources that has been obtained specifically to your company, for you to be able to reach out to them and call them on their cell phone. These requirements are a real threat to those that telemarket. We've seen stats that 1 out of every 3 households in the U.S. are wireless only. So that dramatically increases the odds for falling out of compliance. The CPA has a good faith defense which protects compliant businesses from liability for errors with regards to compliance with do not call rules. So if a business maintains records of compliance, it trains its employees properly, it subscribes to the national DNC list and calls places as a result of an error, might not be held liable for that violation. However, there is no good faith defense with regards to ATDS or pre-recorded call violations found in subsection 227B. I've seen plaintiffs have been arguing that section is a strict liability statute and that businesses are liable for violations even if they attempted to comply with the law. I've seen where this argument's not always successful, but I want to make sure you're aware of the claims plaintiffs are making on this. Bill, anything you want to add to that?
Steve, exactly right. The thing is, you not only have to anticipate what a judge will rule, but also what a plaintiff will allege. You don't want to be a target because getting the argument in front of a judge, first of all, you can lose. Second of all, it's expensive. So anticipating what a plaintiff can argue that's within the realm of possibility and not something totally ridiculous is probably a good compliance step because we don't want to get into the next section, the enforcement section, if we can possibly avoid.
Great, Bill. As far as the DNC registry is concerned, the FTC announced updated fees starting on October 1st of last year. The cost of the list increased $1 per area code to $59, or a total of $16,228 if you're accessing all area codes. I just wanted to give you some registry facts as well. So as of September of last year, the number of active registrants on the list was more than 224 million, so an increase of 2.8% from the previous year. There are also more than 3.7 million complaints regarding unwanted telemarketing calls. So although the total number of registrations increased slightly, the total number of complaints actually decreased by 2.4% from the previous year. 0.2 million of those complaints were from consumers receiving pre-recorded messages, and 1.8 million were for consumers who had requested that companies stop calling them. To give you a little bit of state trivia here, New Hampshire has the percentage, or the highest percentage of registrants based on its population, and not surprisingly, Alaska had the lowest number based on its population. Lastly, although the total number of registrations on the registry continues to increase, continue to see increased scrutiny around pre-recorded messages and active enforcements for do-not-call violations, the businesses accessing the list decreased by around 1,300 companies. On May 9th last year, the FCC issued a declaratory ruling that sellers may be held vicariously liable for violations of the TCPA made by third parties. Ruling was based on a lawsuit by a plaintiff alleging he had received 30 calls in violation of the TCPA, both pre-recorded and live calls, and that his requests to not be called in the future were ignored. The defendant argued that it could be held liable for TCPA violations by its third-party independent contractors. So he had been silent on this issue up until this point, but ruled that a seller may not, or rather a seller may not be directly liable for a violation unless it initiates a call, but that could be held vicariously liable based on the relationship with third-party telemarketers. That also went on to state several factors which could be relevant to determining if vicarious liability exists. And those are whether or not third party has access to information and systems that are normally within the seller's control. In other words, detailed information regarding the nature and pricing of the seller's products and services, or seller's customer information. It also includes the ability by third parties to enter consumer information into the seller's sales or customer systems, authority to use the seller's trade name, trademark, and service mark, whether that seller wrote, reviewed, or approved third-party scripts, and whether the seller knew or reasonably should have known that the party was violating the TCPA on the seller's behalf, or failed to take effective steps within its power to force that telemarketer to cease that conduct. The EC left open the possibility of imposing a higher standard of liability with respect to its DNC rules. So FTC and the state AGs pushed for this as well, and specifically it stated that the on behalf of language used in connection with its DNC rules could to establish liability. So really what this does is open the door not only for the FCC to revisit the issue in the future, but for courts to reach their own conclusions regarding what the phrase on behalf of means under the TCPA. So our recommendation is that you review your contracts and relationships to ensure compliance with the current law in this ruling, as well as establish documented monitoring and enforcement programs of your third-party vendors. Of Management and Budget also approved FCC regulations related to a Public Safety Access Point DNC registry, or a PSAP DNC list. A PSAP, in case you're not familiar, is a facility designated to receive emergency calls, and it routes those calls to emergency personnel, service personnel such as police, fire department, ambulance services. This rule prohibits persons from using automatic dialer or robocall equipment to calls to numbers on the PSAP DNC registry, define such equipment to have the same meaning as an ATDS does under the TCPA. So those using an ATDS or robocall equipment must register to access the PSAP DNC registry and use a version that's no older than 31 days. Violations are subject to penalties of this list between $10,000 and $100,000 per call, depending on whether the violation was negligent, reckless, or willful, depending on whether it was a first or subsequent offense. So it's important to note that there is no safe harbor as with the consumer registry. Lastly, the OMB approved these rules on 3/26. Today, the list is not yet operational. It's supposed to be published in the Federal Register, and when that becomes available, we will notify everyone, and it should be about 6 months. The effective date will be 6 months after that's published in the Federal Register. Now, state updates. It was not really overly active year at the state level for new legislation, but they do continually refine and update their laws. The important takeaway for the slide is the urgency to stay abreast of changes. Many states have their own unique set of laws that were created many years ago. So technology such as over IP, texting, and cellular technology is progressing much more rapidly than most themselves. And as this continues to happen, we believe we'll continue to see states review and update their laws. So here's a handful of new changes we saw at the state level. Arizona amended its telemarketing laws by adding text messages to its previous prohibition against the delivery of pre-recorded solicitation messages. Now, exemptions include prior consent or an EBR. The federal rules requiring express written consent would serve as a floor and should be adhered to. Florida is historically an active state with updated regulations as well as enforcement actions. So several changes occurred to their telemarketing rules, including extending internal DNC requirements to cover charitable solicitations, narrowed the registration exemption for supervised financial institutions, and then lastly, they also changed information that must be provided as part of the registration process. So if you're applying for an exemption, they have the right to ask for scripts and contracts and really just request any compliance documentation that you might have. Lastly, Illinois introduced statutory damages for consent for each violation, as well as updated its record-keeping requirements that a telemarketer must maintain. The majority of the state rule changes made during the last year really revolved around telemarketing registrations, pre-recorded messages, and text messages. Many of these changes not only impacted business-to-consumer campaigns, but were also applicable to B2B campaigns. We added clarification that delivering pre-recorded messages to businesses as well as consumers required internal DNC procedures, and also amended rules for non-solicitation calls. North Dakota amended their rules with respect to the delivery of pre-recorded messages and text messages. Many states are really just reinforcing that placing text messages are essentially falling under the same requirements as calling cell phones. And then Utah amended its registration requirements for registered agents and now requires a criminal history record be submitted by all key employees in order to process the telemarketing registration if applicable. on to the last regulatory update slide, Vermont has historically never charged a fee for their telemarketing registration. They are now charging $125 to register as a telemarketer. And then lastly, Wisconsin amended its rules to bring text messages under the definition of telephone solicitations. And it also prohibits the delivery of misleading or inaccurate caller ID information, which is actually already a requirement under the federal rules. So to wrap up the 2013 regulatory section, full of changes to the rules at both the federal and state level. We recommend that you task someone in your company with being familiar with changes and updates as they occur and monitor them. If you're one of Compliance Point's customers, you receive updates from us on a regular basis. If not, we recommend that you subscribe to a service for these updates. And any changes that you see that could impact your campaigns and your marketing efforts should be disseminated across your company and make action plans to change processes and to ensure compliance. Lastly, just make sure you're complying with the most restrictive set of rules, whether that be the federal rules or the state rules. It's important that you ensure compliance with the most restrictive set. And I'm going to turn it over to Bill.
I'd like to add on Bill's behalf that Collins and Cantor is also a primary source of these kinds of regulatory updates to their clients as well.
And I'd like to add on the experience side that I've worked with Compliance Point, I think, for more than a decade, if not very close to that, and I think that the company does better than anybody else out there with regard to database issues and general compliance issues, and has been an invaluable resource to me in my practice. It's a real pleasure through the years working with them. My experience personally is close to 2 decades of working in telemarketing compliance. Every state that's ever been active, I've been out there and met with AGs, and certainly somebody from my firm has. I think when we get to these next slides, the idea that you should have in the back of your mind is that there are patterns of enforcement, that these things go in waves, and some states become more active, and some they're less active as people change offices. Sometimes the FCC is more active, sometimes the FTC is more active. But something you can take away from every single enforcement action is, for the most part, it could have been prevented with some compliance work in advance. These things I'm about to talk about don't involve, trying to commit fraud or scam somebody else. I mean, no one here is going to advise you on how to do that. The things we can advise you on are how to avoid the technical and things that end up costing companies a lot of money. And I used to say that I thought $1 spent on compliance was $10 on litigation or enforcement, and you could use whatever unit you want. You could use man hours or whatever. But in litigation I've been involved in recently with the fines and the class action, I'm moving toward 1 to 100. Like your time, effort, and money resources spent on compliance is worth $100 of fines or enforcement action. So I just can't emphasize enough how take a look at some things in advance can prevent much worse things happening later. The first types of enforcement I'm going to discuss are federal actions. They can come from 2 sources, the FTC, Federal Trade Commission, or the FCC. As said, you need to look to the most restrictive rule that applies. And the FCC and the FTC have separate, very similar, but differing slightly sets of rules. The FTC enforces the Telemarketing Sales Rule and the FTC Act, while the FCC enforces the Telephone Consumer Protection Act and its regulations. Generally, the FTC is much more restrictive. So we'll talk about cyber actions first. Financial Institute paid a $32 million settlement. That's a lot of money for me. It might not be a lot of money for some banks, but I imagine that a lot of this could have been prevented with less than $1 million worth of compliance. The first issue right there is debt collection calls, like Steve said, business-to-business calls can be subject to some of these rules. Debt collection calls, which are not marketing, can be subject to these rules, especially the rules regarding calls to cell phones. They weren't affected by the October 16th change that Steve just described, are subject to rules on cell phones, are subject to rules on pre-recorded messages, both at the state and federal level. And the third, the fourth there, some consumers felt harassed, is just extremely important, and it's kind of another mantra of mine that any complaint is a bad complaint. Your job is to prevent complaints. It's not just to comply with the law. Because when an agency, whether it's a state AG or the Federal Trade Commission, gets a complaint about you, their first action is to assume the consumer is right and demand an explanation for you. If the FTC gets 100, they won't do what the number is, but they get 100 complaints about you, they'll issue you a civil investigative demand. The civil investigative demand won't just cover whatever the complaints were about, normally national do not call list issues. They'll kick the tires on every aspect of your compliance. And it's not easy, and it's not fun. And some companies are going to run against that 100 number no matter what, because you call a lot of people, over time you're going to get complaints. But you need to minimize those and make sure that they are not frequent, because each time you're complying, you get complaints, you're going to have problems. The second issue there is FCC citations, and this is a reason why the FCC is not the most active of enforcing of the telemarketing rules. They cannot fine you. The agency can't fine you unless they issue you a citation first. A citation is a very formal-looking document, and it says you've been cited for such and such a violation. Up a few years ago, once you got a citation, they would never undo the citation, but they will now. I don't want to call it a free bite at an apple. It's a chance for you to review something that has come to the FCC's attention. But under regulated telecom or some other entity that has already been cited or is subject to FCC jurisdiction, citation itself is not something you have to worry about monetarily. It's something you have to worry about, make sure you fix the problem, but it's not something that you're facing a big fine right away. The issue there was a mortgage broker that paid $7.5 million to settle allegations of violation of the internal do not call list. This complaint was almost totally, this issue was almost totally consumer complaint driven. The company was very aggressive with regard to its calling, which is fine. Sales are okay, but when there were complaints that came to the company's attention, they continued with aggressive practices, and FTC eventually came at them. The issue, telemarketer ordered to pay $5 million to reimburse victims of a car bank scam. When making fraud or misrepresentations, the FTC is going to kick your door down. So don't. When it comes to issues that are of questionable truth or need to be very, very conservative, realizing that a consumer, A, be taken at his or her word when they complain, and B, will be pretty much as a least sophisticated consumer standard. And if you make a representation, you better try to put yourself in the shoes of who's listening to it, knowing that the government is going to back everything in that person's favor. Interesting point here is that it was an international company, no exemption for calls from Canada, calls from India, whatever. Now, are some of those entities judgment-proof? Potentially. But if you're a United States company or a company with assets here, don't think you can avoid these rules by calling internationally. The thing with the next thing, when you're getting into free offers, you need to be very careful at the state and federal level about making sure that these are very well explained, that a consumer's not going to claim saying that he or she was defrauded. Interesting point that text messages just as subject to these restrictions. You don't get out of telemarketing laws because it's a text. The laws are a different story, not covered today, but texts and calls are pretty much regulated by the same set of FTC and FCC rules. Next, we have state enforcement. States vary from to extremely active, and the change often based on who the Attorney General is or who the governor is. We're going to get in the next couple slides on just really some of the most active states. A lot of states, as or it might be later in the presentation, still have their own do not call list. Why? The benevolent explanation is the term varies slightly, and the benevolent explanation is these attorneys, Attorney General, enjoy the press, like suing telemarketers. We don't want to be the telemarketers that they're suing. Florida still has its own do not call list. More active enforcement of its registration requirement, which is kind of like a license. You have licenses at federal level, but you do at the state level. Florida is pretty active. The very first thing Florida will do when it gets a complaint is send a letter to you, very much like a form letter. You can't ignore them. If you ignore them, things get worse. If you address them very often, they'll go away. It costs a little money to address a complaint like that, sure, but it's a lot less expensive than if you get sued. Is from you never hear from them to being more active. Kansas is interesting because it does not have its own do not call list. It has its own do not call law. So it'll sue you for violation of the federal do not call list based on Kansas law. Are they allowed to do that? Probably, if there's a big fight about it. But these settlements, well, they're not $52,000. There probably was a default. There's probably somebody who ignored it. Normally, that is willing to settle for an amount that makes it painful for you, but not so much that you want to try to get their entire regime struck down in court, which is an example of how the compliance is just dollars and time much more effectively spent after the fact in litigation. Missouri is also extremely active. Missouri has its own do not call list. And more importantly than that, the terms of the Missouri no-call list differ from the federal. For example, Missouri only has a 6-month exemption for established business relationship, while the federal list has an 18-month. And there, I can tell you the number of times I had to explain that to people, and they go back and ask me why Missouri still has its own do not call list, and I give that benevolent, not so benevolent explanation I just said. Similarly, Tennessee has its own do not call list. These are just of the most active states here, sending people for do not call, and just because you're compliant with the federal no-call list doesn't mean you don't have to still get the Tennessee list, get the Missouri list. Make sure it doesn't apply to whatever campaign you're talking about. For the most part, they have similar exemptions, but they have identical exemptions from the federal ones, and you need to check off both categories, state and federal. Go back to looking at what rule is most restrictive. You need to apply the most restrictive rule, whether it's state or federal, to a given call. And that means there are states where there is no do not call list at all, no state do not call list, but you still have to comply with the federal list because that's the one that's more restrictive. Mississippi and Wisconsin also quite active. Wisconsin is a strange state in the sense that it will see you a form letter when it gets a do not call complaint, and it will say that you are required to, quote, register, close quote, with Wisconsin's no call list, which this is something that has caused more confusion with my clients, I think, than almost anything else, because there is a state do not call list and there is a state registration, and they are not the same. Wisconsin, I think Tennessee for that matter, also in their complaint letters will say you need to register with our list, which is confusion. It's just a word. They can define it however they want, but they're defining it differently than most people define it. So you need to watch out in Wisconsin. When they say register, they mean purchase and implement their do not call list. Wisconsin does not have an established business relationship exemption. Missouri had a shorter one. Wisconsin doesn't have one at all. You can only call your own customers for marketing with express consent, and you need to keep good records of that express consent. Like Steve said, it has no established business relationship exemption at all. Indiana is quite active on enforcement too. And this kind of brings me to the third area of enforcement. I know Ken is going to talk about it in a little bit, but the patterns of enforcement I mentioned at the very beginning, right now, private enforcement of these statutes is the biggest deal. It's the most serious thing. If I had to rank them, it would go private enforcement, FTC enforcement, state enforcement, FCC enforcement. So private enforcement right now is extremely important. And it's extremely important because private entities that are suing you don't care about consumer harm. They don't care about what good company you are. All they care about is money. They're suing you in class actions. Go out and do a Google search for TCPA class actions, and you'll probably, well, I hope you'll be okay, but it might cause you to lose breath for a second. Ken's going to talk about the TCPA class actions. It's the cottage industry. You do not want to be a defendant. I think you can avoid it with some compliance work. You can be totally safe, but what you can do is avoid being low-hanging fruit. You can avoid being down near the edge. You can make it so any one of these bozos that's trying to sue you is going to look at you and say, this is a very hard target. All I care about is money. I'm going to move on to somebody easier. That's, you can't be perfect, but you can make yourself, I think you can do business. I'm not a lawyer who says, oh, you can't do things. There are ways to do things right, and I think in the TCPA you certainly can. The way I'm going to talk about it more depth is the California call monitoring class action. It's a cottage industry as well. Do a Google search for California call monitoring class action or settlement, and you'll find some scary stuff. There's a law that says you can't monitor a telephone call without the consent of one party to the conversation. Monitoring includes recording, wiretapping, listening in through an extension, a supervisor listening in, or even text chat monitoring, which is a newer area that's a new area of communication that was invented after the statute is. But monitoring is very broad. California and about 6 other states say both or all parties to a conversation need to consent prior to it being monitored, and it provides for liquidated damages of $5,000 a call. In 2006, or was it 2004, that Kearney case came out, and it said, this law applies if you're in California and you're monitoring the call. If you're in Missouri calling into California, it's Missouri law that applies. Kearney turned that on its head, and a few years later, class attorneys in California are suing a lot of people saying, you disclosed it was being monitored, pay me $5,000. Oh, well, that's pretty bad. Oh, on top of it, pay me $5,000 for every person that you did the same thing to. Really potentially catastrophic damages. You do not have to get express consent. You do not have to say, Mr. Rainey, may I record this call? If you say the call can be monitored and I continue with the conversation despite that knowledge, consent is implied. And I've had people say, gosh, that disrupts the presentation. To do it, but you have to do it. You have to disclose. A beeping tone, probably not enough. You need to say it's being recorded or monitored, something like that gives the consumer reasonable notice that he is being monitored. It applies to calls from California. This is the most ridiculous thing I've ever heard. Plaintiff firm in California calls your 800 number, and your that answers the phone. They might have the options, and the very last option would be your calls being monitored. Hold the line for a live operator. This company would opt out of that disclosure early by pressing 0 or the equivalent, and then say, you monitored me without me knowing it, I'm suing you, despite the fact that the IVR had the disclosure. So what the fix is you have to make sure your IVR cannot be bypassed. If there is a disclosure in an inbound voice response system that the call can be monitored, don't allow it to be bypassed by an early press of 0. If they press 0, they still get the disclosure. Similarly, absolutely scary thing. How do you know you're calling California? You call an area code. You make sure that the California area code get the disclosure. I just got a suit where a guy with a Michigan number said in California, says California's law applies to calls to that number. There is absolutely no way to know where somebody you're calling on a mobile number is, right? It's impossible. We're going to move and try to get that struck down for various good reasons. They're very, very good reasons, but the fact is it's going to cost money to get that done. You just need to be aware that for calls to mobile numbers, it may be that you want to disclose monitoring everywhere until this is resolved because you don't know where a mobile person is. It is absolutely scary, and it's based on this Kearney case. The lessons learned are to duplicate what Steve said a lot. record keeping is absolutely important. If you have good records, training, and good communication when you get one of these complaints, all this stuff can go away. One of records are important. Calling a list of numbers that provided to you by a client, that the client knows how those were created and has good records of them. All records were provided to us by the consumers when they signed up for a credit card, and we have their applications and the dates. Pretty good. You need good records, because you don't, like I said, when a regulator gets a complaint, the first thing they do is assume the consumer is right. You have to prove they're wrong, and the way to do it is good records. And the final point there is, if you get a notice, you just can't ignore it. Sometimes notice isn't bad. Sometimes notice is a good thing, because it allows you to take a look at your compliance procedures and fix something at a very low cost. And if you ignore it, it might get more expensive. So when you get something like that, even if it looks like a form letter, you need to have the proper people look at it and respond. Thanks.
All right, thanks, Bill. Steve and Bill have given us the review of 2013. We want to go ahead and look at some bills that have been proposed that could go into effect in 2014. To ensure we have enough time for everyone's questions, I'm going to go through this pretty quickly. The bill numbers are on here, and we will send out the link to the presentation following the webinar. So if you have further questions, please feel free to contact us directly. The first topic we want to talk about is call center relocation. If you're in the call center space, you're probably familiar with all of the bills that have been proposed over the years at the state level and even at the federal level when it comes to putting restrictions on the relocation of call centers. Restrictions would include limiting grants from the state, loans, or tax benefits from the state. And as you can see here, Arizona, Maine, and New Jersey already have bills that are progressing in 2014. We included Minnesota because they've been considering a bill as well. In 2013, though, and it's been stuck in committee since the spring of 2013. So Minnesota doesn't look like it will be one you're going to have to worry about. New York and Tennessee are also considering similar bills, and surprisingly, the federal government has a bill in the House and in the Senate that was the relocation of call centers, or again, penalize companies were to relocate their call center overseas. If you have any call centers located in the states that we just mentioned, we just need to keep an eye on these bills to make sure that you know if they go into effect. Steve mentioned in his review, a number of states are starting to expand their coverage of their telemarketing and do not call rules as technology evolves. A good example, this proposed bill would expand their definition of telephone solicitation to include voice calls, text messages through a landline, mobile phone, or internet telephone service. So this actually brings VoIP phones into the scope of Florida's rule. What we see here is actually on text message vendors, or those companies that are sending text messages into Florida. Depending on how the final wording comes out, we believe there's a chance that those companies that are only sending text into Florida may now be subject to Florida's registration requirements as a telemarketer. This is important because even if you're exempt from Florida's registration requirements, you're still required to file an affidavit of exemption. And so this could be work that text message vendors have not had to deal with in the past if this bill were to move forward. New Jersey's also considering some legislation related to text messages. They're typically been a less active state when it comes to enforcement of their rules, but this bill would also limit text messages to wireless numbers to New Jersey residents, similar to what we just discussed with Florida. Could soon become more active with their enforcement than they have been. The bill here is looking to establish a telemarketing fraud investigative unit, and this unit would be responsible for looking into any complaints related to telemarketing or do not call violations. So this could be violations of the no-call list, failure to disclose telemarketer's identity or the purpose of the call the allowable calling hours, and so on. The bill in committee, but if it passes, we do expect, again, New Jersey to become very active very quickly. This bill from Indiana could have a major impact, we believe, on the lead generation space if it were to go into effect. Right now, this bill is proposing to extend Indiana's do not call statute to provide certain prohibitions that would apply to telephone solicitors but would also apply to suppliers in consumer transactions as well as callers in the commercial telephone solicitation. So putting it in plain language, this basically allows Indiana's AG to go after anyone in the lead generation chain from beginning to end, or in the telemarketing chain from beginning to end. It would allow the AG to hold sellers responsible for non-compliant activities of their vendors, vice versa. While we've been of the opinion that AGs and the FTC and FCC could do this for a number of years, this would just put it into writing and make it very clear for everyone in this space. The big implication is this bullet, that underlying section, it would put a prohibition against companies from selling, transferring, or making available for solicitation purposes someone's phone number if that is on the Indiana DNC list. So if we interpret this broadly, this could mean that a lead generator gets a lead from someone in Indiana, they cannot sell that lead if the number's on the state's DNC list. And conversely, if you have a list that you want your telemarketing vendor to call, you might have to remove Indiana DNC numbers from that list before sending it to the vendor. This bill would have a major impact if it goes into effect, so we do recommend keeping an eye on it. News is currently considering a variety of bills that would impact direct marketers. The first is related again to text messages. This bill would require prior consent to text a consumer for marketing purposes. If you're with the TCPA changes and the federal rules for the past few years, you're probably thinking it's not a big deal, but this bill does not differentiate between text sent via a dialer or text sent manually. This would require prior consent to send any text message for solicitation purposes to a resident of New York, so that would be more restrictive than what's out there at the federal level. Next bill would also be more restrictive than the federal rules. The federal rules allow calls between the hours of 8 a.m. and 9 p.m. The bill would actually trim an hour off of that callable window and only allow calls between 8 a.m. and 8 p.m. An interesting one for those of you that might fall in Oklahoma. As Bill mentioned, those states that maintain their own DNC list are typically the more aggressive enforcers of their DNC laws, and this bill would actually eliminate the EBO exemption from Oklahoma's do not call list. So they would move from a market in two-state to a state similar to what Wisconsin or Indiana are currently doing. This obviously would have a dramatic impact on anyone that calls in Oklahoma, so we do recommend keeping an eye on this bill as well. The bill listed here from Utah has actually already gone into effect. This is tightening up the requirements for companies that have to register in Utah as a telemarketer. As Steve mentioned, there were already some changes in 2013. This bill requires a company to make sure its registration application remains up to date if there's any material change to that company's status, such as its ownership or legal status. Good news with the last bill that we want to cover. Wisconsin is currently considering eliminating its state do not call list and pairing it with the national do not call registry. This would save companies money. If you're already buying the Wisconsin state DNC list, you're paying at least $500 a year and probably more than that. Again, this would eliminate the list and roll it in with the national registry. It passed Assembly just recently with unanimous vote. It's on the governor's desk now, awaiting signature. I'm going to go over to Ken. He's going to give us some updates on the TCPA.
Thanks, Matt. And Bill did a good job of talking about the risks for TCPA. So really, I just want to focus in on one or two things relative to this. Over the past few years, I've been retained as an expert witness in nearly 24 different TCPA cases, and they have a very similar trend. Thing that is very similar is the fact that many of these cases that involve text or calls to mobile phones are because of wrong party contacts. Seen last year a 65% increase, according to some sources, in TCPA class actions. And as Bill said, the real danger here is the fact that statutory damages that are possible are absolutely disproportionate to the actual injury. So you're talking about a potential of treble damages per call of $1,500, and we're talking about actual damages of perhaps a few minutes of time off of your mobile plan, or whatever you might be charged for a text message or a fax, whatever a sheet of paper costs, and so on. $1,500 versus that. And of course, the damages are uncapped. We also know, and one of the things that I'm just going to hone in on here is the fact that the big problem we have here with the TCPA class actions is the fact that, like residential lines, which have 411 data sources that you can keep up to date on changing telephone number information, there is no similar publicly available source for mobile phones. We know through our research and our analysis that 20% of the typical CRM has incorrect wireless information for their customers in it. When you also assume that in demographics above 70% of the population is mobile phone, uses mobile phone, and in some cases mobile phone only, you can see that because you can't determine if your information is correct and you place these dials, the majority of these cases have been due to wrong party contacts, particularly in debt collection space, where they may do skip tracing or they may go out to other append data sources to try to get better information. And so it is a very dangerous and scary environment right now. There is a petition before the FCC right now from Healthcare Services Incorporated that would alleviate this to a certain degree. Their petition specifically talks about non-solicitation calls, but they're asking the FCC to include in the definition of express consent one call to the wrong party, as long as the company that made the call can prove that the number they called belonged to the correct party, if they correct their records and don't make any subsequent calls. So that's before the FCC now. That would help a lot, but you know how that's going to turn out. The bottom line of all this is that everything here relates to the use of an automated telephone dialing system, and we haven't even seen these yet for new prior express written consent standards that went into effect October 16th of last year. So we do know we've seen a lot of television ads. We've seen lawyers adding staff. We see building and bulking up for what we believe will be a large increase in these kinds of actions. Anything quickly you want to add to that?
Right.
Okay, thank you. I'll roll back to Matt now and very briefly talk about some changes in Canada.
All right. So I want to shortchange our neighbors to the north, so I want to talk about a few updates from Canada when it comes to email and do not call list. The first is Canada has finally provided an effective date for their anti-spam legislation. This has been years in the making. The anti-spam legislation is better known as CASL, and it's set to go into effect July 1st of this year. Even though the majority of you are likely located in the U.S., this could have an impact on you because it does apply to any commercial electronic message that's received within Canada, even if the message originates outside of Canada. If you market via email, you're likely familiar with canned spam, but CASL has a few components that are a bit more restrictive than what's required by canned spam. The first is its applicability. Canned spam is limited to emails. As currently written, applies to emails, but also text messages and social media messages, essentially any commercial electronic message that could be sent to a resident of Canada. CASL has an opt-in requirement, and if you're familiar with canned spam, spam only has an opt-out requirement. If you want to gain that opt-in to email residents of Canada, We provided the items that are required when to obtain that consent. You need to provide the consumer with a statement that outlines the name of the entity or entities that are requesting consent. You also need to provide a lot of contact information for that entity, including their mailing address, phone number, email address, and their website. You also need to include a statement that the consumer could withdraw their consent at any time. A little bit of news: implied consent is allowed, and this does include a prior business relationship with the consumer. The key thing there is you need to make sure you have the records to demonstrate that business relationship if you're going to rely on the implied consent provision. Implied consent can also be claimed if the consumer has provided your business with his or her contact information, absent instructions to the contrary. Recommendation is that if you could potentially send messages to someone in Canada, make sure you maintain the necessary records to document consent, to prove that you are allowed to send that email. And also, if you're purchasing any email list, any data from your data providers, if it has Canadian email addresses within that data, once this goes into effect, you could not email or commercial emails to those addresses until you're able to obtain that consent. And at that point, it's going to be pretty difficult. Lastly, just a quick update on the National Do Not Call list in Canada. Much larger than the U.S. Do Not Call registry, Canada's list only contains 12 million numbers. We do anticipate that's going to grow. They're likely to make registrations on the list permanent within the next year. Right now, registrations last for 6 years, but that keeps getting extended as that expiration date approaches. Canada's been pretty active. The CRTC, as you can see the stats here, has about 181 active investigations at the moment, and they've, in the time since the list has been active, imposed over 60 monetary penalties. We want to remind you that if you're calling into Canada, there is a requirement to register, even if the calls you're placing are exempt. So we strongly suggest that you evaluate those registration requirements and register with the National Do Not Call list operator if required. That registration is free of charge, so be easy to comply with the registration requirement in Canada. This concludes our presentation. We've provided our contact information along with Bill's contact information. We will be posting this webinar to the Compliance Point website in a couple of weeks, and we'll send that link out to everyone in case you want to reference it at a later date. With the time we have remaining, we will answer the questions that we've received through the chat window during the webinar. Thanks for your time.
And put out a final thanks to Koplowitz and Canner, and particularly Bill Rainey, his insights in joining us today. We've enjoyed our partnership with his law firm. And we don't get to all the questions today. We don't have very much time left. We be assured that we will respond to every question we get through email. Thank you for your attendance today.
So we've had a few questions come through the webinar. Again, we thank you for your attendance. The slides will be available on the Compliance Point website in a matter of weeks, and we'll add a notice to the attendee list once it's posted to our website. So quickly, we'll knock out a few of the questions that came in. The first question, Ken, I'm going to let you take a shot at. The question is, if a customer provides you with their cell phone number via email message or voicemail message, or if they specifically say on a marketing call, please call me back at my cell phone number, can we legally call them? This person saying in all three cases the customer provided their number and asked to be contacted, and also with an auto dialer has manual dial selection, would be allowed to place those calls if they type in the number that's provided.
Okay, good question that we run into all the time. On the first part of your question about whether you can call the person back that gave you a phone number, there are two considerations. One, am I using an ATDS to place the call back? And then secondly is the purpose of the call. So if the purpose of the call is for solicitation and you're using an ATDS, then you may not make that call to that person without prior express written consent. It's not for the purposes of solicitation, then you could place that call because they provided you the number in the context of business. So it's for a service call, something like that. So remember that there are two issues, do not call and the ATDS call mobile phone prohibition. On the dialer question, all I'll say about that is the courts are all over the board on the scenario that you've provided here. It could be that might be fine, but we've had courts that rule about capacity and how easy it is for you to go from manual to dialer. So I would recommend having that dialer settings analyzed by a professional and have it documented and kind of go from there. Sorry, I can't give you a firm answer, but that's a very fluid situation right now.
And Bill, I'm going to turn this next question over to you. It's a two-part question, I believe, related to the California call monitoring issue that we were discussing. One part of it is, do we have to disclose that website chatting could be monitored? And do we have to disclose if text messages may be monitored?
I would say in both cases you do. The statute applies to communications. There's 3 statutes in California. One applies to wireless lines, but the fact is at least one applies to the electronic communication. So I would disclose in those circumstances for sure in California. Other two-party consent states.
Thanks, Bill. We've got time for one more question. This question is related to caller ID as a result of the Wisconsin enforcement that we discussed. The question is the term private or blocked considered a violation of the Wisconsin caller ID ruling if that's the company name displayed on caller ID? Steve, can you take a shot at that one for us?
Sure. If you remember, the caller ID requirements, even at the federal level, state that you have to display alpha as well as numeric, if technically possible. So under the federal rules, if you're going to, you have to display, including the name of the company. So you adhere to those federal rules in this case and display the company name as well as a phone number.
Well, to let everyone go at 3 o'clock, so that's all the time we're going to have for questions today. We did receive additional questions. We'll respond to each of those with an email, and our contact information is here. So if we didn't get to your question, please feel free to reach out to us. Again, we'll also be reaching out to you to make sure you get the answer you were looking for. Thanks again for taking the time to join today.
Thank you for joining us today. This concludes today's web conference. You may now disconnect.